So welcome to this special meeting of the Bennington Select Board. It is, July 15th, is that true? Yes, Monday, July 15th, 2024. We are in the third floor firehouse. My name is Jeannie Jenkins. I have the pleasure of chairing this board, and I'll ask our board members to introduce themselves, starting with Jean. Sorry.
Good call.
Jean Connor.
Hi, Sarah Perrin.
I'm Ed Woods. I'm Tom Haley.
Clark Adams.
Nancy White.
Excellent, thank you. And also with us tonight, we have our special guest, our trainer, who is James Carroll, who has come down from Middlebury to be with us tonight. We also have our town manager, Stu Hurd, who is also serving as our recorder for the evening. And we have Jim Byers on the camera for Cat TV, and we always appreciate Cat TV filming this for us.
And we're filming for future.
Yes, this is not a live broadcast. This is for future. All right. So with that, Mr. Carroll, I'm going to turn it over to you.
All right, thank you very much. I appreciate that, Madam Chairwoman. Well, maybe a brief introduction, just so you know I didn't blow out of nowhere to do this. And I think they're going to be happening more frequently, particularly with some recent legislation that happened. But I'm an attorney at Carroll, Bow, Pell, and Kite up in Middlebury. Been practicing since 1985, and since then, my practice, after about 2 or 3 years, pretty much grew into municipal, local government-related issues as clients. I do a lot of work through the Vermont League of Cities and Towns and the Property and Casualty Intermunicipal Fund, who assigns claims that are brought against municipalities to various attorneys that they have on staff and have chosen to use. And I'm one of those attorneys, so I'm dealing with a lot of defense of claims that are filed against municipalities in both state and federal court. And I've done a whole bunch of trainings, DRBs, quasi-judicial processes, etc. So I appreciate Stuart's asking me to do this. It's really, I think, the first time I've done like a training for select board members, just sort of as a unit. I guess we have about an hour and a half session. And I don't want this training to turn into just a presentation of some sort. It's much more beneficial for everybody. I think if we can get into a conversation and making sure that questions that come up. I do have a bunch of materials that I've prepared for the purposes of at least initiating our conversation and starting from there, and a bunch of areas that I think might be of interest to cover. Are there any board members who are like brand new, who are new as of March? So 2 board members.
Yep.
Great. Well, thank you for being here. And I hope it's instructive. I intend it to be. And if it's not, stop me and we'll talk about something else. But I also have and prepared, Stuart, I don't know.
Every board member has that in their
Oh,
packet.
they have that outline, great. So this is kind of my working outline that I was gonna start in with in terms of providing this kind of a training session. And there's a bunch of materials that I've compiled for my own purposes into a notebook that are materials that I frequently refer to when I get questions from the municipalities I represent. And I really haven't counted recently how many municipalities I represent, but it's more than enough. And in addition to kind of some of the longer term issues and the liability issues and the cases and everything, there are also these day-to-day questions that just pop up that need to have some answers either from town managers or from select board members and non-management communities. There are quick questions, questions that you could probably pick up a statute and quickly refer to it, just say, there's the answer that's in this particular statute. So what I've tried to do is to compile those materials that I most often reach for and use when those sorts of questions come up that happen to address, I think, a lot of the issues and questions about governance and select board governance in particular. So I hope they're helpful. They're really there for you to take with you, have on a shelf, maybe never to be seen again, but perhaps pulled off because in there may be some sort of an answer. And I'll go through some of those so that you have an idea of what those statutes are and what they say.
Jim, if I could just interrupt briefly, what I'd sent out to the board are all the materials from the statutes, Constitution that you
Great.
listed. Those materials that were listed that they already have,
They got it.
they should have those, or they are available online.
Perfect. Thank you. And Stuart made available to me, and I went online and saw some of your own policies that have been adopted for your own use, and that's terrific. So I've got that all compiled within here as well. So unless there are questions, why don't we just sort of dive right in with that? I'm kind of providing the information and this discussion with you with the understanding that the law that we'll be talking about, or the laws that we're talking about, are current as of today, but may not necessarily be current as of tomorrow or the next day, or certainly after the next legislative session. So everything that you have or are taking with you, you need to, with the proviso that those laws may have changed or been amended or revised in some particular fashion and way. I also do it with the proviso that there are some issues, many issues that come up where the facts are so specific and material to a particular set of circumstance that it's really to your advantage to seek the assistance of your town attorney and certainly your town manager to try to get some of those questions answered, because there are many, in fact, most questions that come up that haven't necessarily been answered before. And you're looking to apply laws and rules and trying to guess how a court or a judge or a hearing officer might determine that particular issue given the law that does exist to apply to that. So with those provisos, let's just sort of launch into this. So I just chose to start just to make sure that we're all getting brought along with the same baseline of information as we move forward. And some of that baseline of information, I think, comes out of the oath of office that you have all taken, I assume, at this particular point in time, which is contained in your materials, but it's basically to do the best job you can possibly do based on the knowledge and information you have on behalf of your citizens. So you're really here, the concept of being a select board member is that you're doing the people's business. At any particular point in time, when the board is meeting in full like this, and on numerous occasions when you are somewhat acting independently or investigating things or looking into things, you're doing so in the best interest of the municipality and the people you serve and the people that put you here, not necessarily the best interests as far as you're concerned or your own self-interests. Your interests really have been handed over for the purposes of making decisions to the voters and determining what is in the best interest of the voters. It won't necessarily be all voters all the time, but that's why people with brains sit in your particular situation to try to sort that through. It's also really imperative as the process gets underway and unfolds, and I'm sure you've already been engaged in your meetings. Clearly, I've read some of the minutes of some of the issues you're dealing with, that at all times when you're conducting the people's business, you do so civilly, with an understanding that everybody here is doing the best they can to look after their constituency, which are the voters of the town of Bennington. And differences of opinion are absolutely fine, are in fact imperative. That's how you get to the best decisions and choices that you can possibly make. But that the discourse and the manner in which you engage those differences of opinion are done civilly, are done with an understanding that everybody's doing the best they can under the circumstances, and they just have a different viewpoint. And that those viewpoints get aired, and then a discussion ensues, a vote is taken, and the majority prevails. And you move on to the next issue. So after understanding that you've taken that oath of office, you also have a preamble, which is really great, in your charter. I'm seeing, I did some work for Bennington many, many years ago on one of these claims to the league, but this really has been the first opportunity I've had to actually look at your charter, which is an impressive document, actually. Preamble, the people Bennington reaffirm faith in government of the people, by the people, and for the people, describe this government as a charter with division to review and amend. The charter reflects concern to improve the quality of life for all people and to improve operation of town government. I don't know how you can say it much better than that. And it's important to keep that in mind, obviously, as you're moving into your duties. Next, one of the things I think it's important to understand as a select board is that this board, this municipality, in fact, is a creature of the state legislature. So the way power wielded in a political setting occurs in the state of Vermont is from the state of Vermont and the state legislature down to municipalities, not the other way around. There are many states where they have what's called home rule, which in their constitutions state that all authorities and powers of select boards or local governmental entities, they have all plenary power, basically, to do what they need to do on behalf of their citizens, except what is specifically taken away by the legislature. In Vermont, it's the other way around. It's what's called Dillon's Rule, which is a judicial created doctrine that comes out of the Vermont Constitution. And under the Vermont Constitution, it's the state level that has conferred all of the power to act on behalf of its citizens through the state legislature, through the administration at the state level, and the state judiciary. What that basically means is that you as a select board have been delegated with authority from the state to act, but to only act in those areas for which a delegation has been conferred by statute. So as a select board, you can only act in those areas by locating somewhere in the statutes the authority that's been conferred by the legislature to enable you to make that decision, to make that choice, to pass that ordinance. So if you're in the process of doing something, at every step in the process, you need to have identified a source of that authority that came to you from the legislature. And that's what's called Dillon's Rule. The authority comes in the form of those green books, the Vermont statutes annotated, and the legislation that gets passed at the state level. It changes from time to time. It becomes broader, it becomes narrower. There are certain topics that come up that are new to state government and to local government. And the legislature is always considering whether to confer more power on municipalities, to regulate things, to regulate our Airbnbs, to regulate solar towers, and whether or not they should allow a municipality to get into those particular areas that are regulated in other locations. So that's an evolving, moving target, but you have to find some place in the statute that specifically provides the authority for you to act and do your duties. Statutes include your charter. A charter is basically a statute specific to a particular municipal corporation. So you can think of your charter and the authorities conferred, which came to you through the legislature, as further authorities above and beyond and on top of those authorities already conferred by the statutes, generally. There are many towns that don't have these kinds of charters with these authorities laid out in them, and they rely exclusively on the authorities that are given to them through the statutes. And there are statutes all over the Vermont statutes annotated that confer authorities for zoning, for highways, for health, for junkyards, for a variety of things that are located throughout the Vermont statutes annotated. I'd say the primary source is in Title 24, which deals significantly with municipal government. And you'll see that in the materials that there's a lot of statutes that are specifically coming out of Title 24 that I've included in the materials here. One of the things to keep in mind when you're dealing with your charter, so when Stuart or the town attorney or you are wanting to adopt an ordinance, for instance, under your legislative powers, you need to identify the authority that gives you authority to act in that particular area. And many of those, like I say, are located in Title 24. And you need to have gone to that source, identified that source, and then cited it in the ordinance that you've adopted, which all your ordinances basically do. And as you know, I am sure, because you've adopted ordinances, there is a procedural process for the adoption of ordinances that you have to follow in connection with creating an ordinance, putting it out there, putting it under consideration, taking a formal vote, putting it out to notice to the voters, who then have the opportunity to petition if they disagree with the ordinance, and have an opportunity to put it to a town vote, basically by petition. So there is a process for adopting ordinances, and then you have to find some other authority in the substantive area in which you're dealing. Does that make sense to everybody? Great. So there is a statute that's referenced in here, it's section 872 of Title 24, that basically confers general authority on select boards to act. What it basically says is all the authorities that exist in the statute, if they are not specifically delegated to someone else within a municipality to undertake those duties and to act, then those duties fall to the select board. So you're sort of what's left after everything's been delegated to other authorities within the municipality. All the other authorities that don't address specifically who it is or what official or what board has the authority to act would fall to a select board under this provision that exists in the statutes. That is sort of a baseline that exists in Title 24, that you're kind of the, how do I put this gracefully? You're what's left to act in the absence of some other specific individual or official who's been designated. That's the way it is set up, just as a matter of principle in general. Then there's a whole lot of sections, and I've included a primary one here, 2291, section 2291, which is an enumeration of powers. And there are about 29 different areas in section 2291 where municipalities have authority to act in those particular areas. And again, those statutes is in your material. And it's just a laundry list of items and areas where municipalities have the authority to adopt ordinances and act within those particular areas. So that's the specific enumeration of powers. And to the extent that any of those powers aren't delegated to someone else, they reside with the select board to deal with. There are many other statutes. And principally, I'm thinking property taxation, town highways, zoning, where there are specific statutes as to how those particular ordinances get adopted or how you're supposed to act under those particular circumstances. But this enumeration of powers is basically all of the big topic areas, that deal with highways, that deal with buildings, that deal with personnel, that deal with all the other sorts of issues that you would typically expect a municipality to get into. Then there are additional powers. Reading your charter, it's a really interesting charter. It specifically designates you as the legislative body, the primary legislative body for the town of Bennington. to perform all of the legislative functions with all the powers and authority necessary to perform those legislative functions. So what your charter does is basically set out that it wants you to act legislatively. That's your primary goal. And as we all know from our basic civics courses, there are branches of government that deal with legislative actions and activities. There's the administration as another branch of government. And there's the judiciary, which is your third typical branch of government. And these statutes and the charter follow that basic scheme to put on this particular select board, particularly in Bennington, all of the legislative authority to act, unless otherwise delegated on behalf of the town. So you're the primary body to consider some more of the policies and more of the oversight, basically, if you will, of the government, to set up sort of those operating policies and procedures, to do the big ticket items, there's a specific provision, I think, dealing with buildings and the construction of buildings and the revision of buildings, but bigger, larger, more policy-oriented issues. Your charter also specifically sets up, and the statute does the same, the administration of the town. Bennington has chosen a management form of government, which is a very wise thing for a town the size of Bennington to have done. And what that basically means is that it leaves to you as a 7-member board, that's a fairly large board, as select boards go in the state of Vermont, the authority and power to really focus and concentrate your efforts on legislative type issues, ordinance issues, policies, oversight, basically, of the town government, and to leave to the town manager the administration of the day-to-day activities of the town. Because if you think about a 7-member board trying to engage themselves in the day-to-day activities of a town this size, that becomes very unwieldy and very cumbersome and very difficult to do just administratively. So the statutes and the legislature set up a process whereby municipalities can adopt the management form of government. That is not, when these towns get born, they don't have management forms of government. The town voters actually have to select that they want the management form of government. In this particular case, I'm guessing that the town probably did that at some point in time, but your charter also calls for a management form of government. So whether the voters had voted for it or not, your charter legislatively gave you a government whereby you are the chief legislative body, and Stuart, basically as the town manager, is the chief administrator of those policies, to put those policies into place, to follow your oversight and direction in connection with that. But the day-to-day management of those activities falls on the management form of government to basically undertake those duties. Does that make sense to everyone? And not every town has that. I mean, there are many, I represent many, many towns. I tend to concentrate on smaller ones. They have 3-member boards, and they do the best they can with the 3 members of the board to kind of oversee things. And some of them are picking up town administrators or people who assist the board, assistants, etc. But for the most part, towns your size, with the complexity of the issues you're dealing with, have adopted that management form of government. That's what you've got here, and you've got a big charter. So at this stage, the legislature has basically said you have a management form of government, and that's pretty much it. Now, once you have a management form of government, what tends to happen is that place where the select board was the repository of all the leftover authority that wasn't conferred elsewhere, now really materially goes to the manager. So all that kind of authority that's out there a little bit in a vacuum because it hasn't been specifically addressed as to where that would go, now falls to the manager, basically, to deal with any of those certainly those day-to-day issues. That does not mean that in that kind and form of government, that this body has delegated to the manager its functions and its duties and obligations to oversee the manager, first of all, and second of all, to oversee the policies and to set guidance and to set rules about what this board would like to see for the town of Bennington and its citizens. You know, the priorities, the guidelines, the oversight basically is still with you. And in the end, you do have oversight responsibilities for the town manager. One of the interesting things about your charter, I thought, is that it specifically deals with and addresses issues pertaining to dissatisfaction, if you will, with the actions and activities of the manager, with dissatisfaction of the actions and activities of the select board members, which is actually very unique in my experience, such that under the charter as I read it, and I'm guessing that you're much more familiar with it than I am, but as I read this charter, each of you are subject to a recall, potential recall petition being filed. It's a fairly onerous petition that would need to be filed to do that, with a very limited number of days to gather, I think it's 30%, if I got that right, of the signatures of the voters for the town of Bennington. But that's a fairly unique, maybe I haven't seen enough charters, but I think that's a fairly unique provision in your charter, is that that has been reserved by the legislature to the voters in connection with your activities, or any of your individual activities on behalf of the board. And similarly, in connection with the town manager's job, do you mind if I mention your name, Stuart, in connection with the town manager's job? Is that all right?
No, please, feel free.
Right. But in connection with the manager's job, your charter also has changed and revised to some degree the rules that pertained normally by statute to management form of government. Under the statute, what the rules basically provide in connection with the town manager is that the town manager can't be dismissed, discharged, except for cause. So there's a causal requirement that exists in the statute, which in turn would require a hearing and all kinds of information being gathered and put before the board to determine whether or not there is just cause for termination. Under your charter, there's a couple of different provisions, one of which looks like if there's a vote of dissatisfaction, there's a time period for without cause, basically, to basically ask for the resignation or the termination of the town manager. Again, by majority vote. But also there's a provision dealing with just cause and how that would work as well. So that alters and changes the common law issues in connection with the management form of government. I will say, having discussed all of this, that I had an opportunity to work with Stuart quite some time ago. We had a case or two, I'm remembering, Stuart?
Yes, we did.
And you've got a hell of a manager, and you've got a hell of a lawyer as
Sure,
well.
let me write that down.
Hell of a manager. I mean, he's been doing this for forever, I think, Stuart, long time. And there's a lot of accumulated wisdom and knowledge there. That isn't to say that I'm asking, everybody's entitled to their own opinions. Just giving you, for what it's worth, an opinion of someone who's worked with them. And someone who's worked with your town attorney is also great. And interestingly, I see in your charter, which is actually fairly typical, it's the board that designates whoever the town attorney is. It's the board that makes that determination or decision, who to hire and who it is that would act under normal circumstances on your day-to-day corporate attorney situation. If they're not otherwise appointed through a claim that exists through passive, that's a different situation where they then designate whoever it is that's going to be representing the town. So with all of that in mind, your charter, interestingly, provides an out for voters that typically does not exist by statute in terms of dealing with its elected officials, you, and you're dealing with Stewart, who's an appointed official. So, the other powers that I thought were interesting in your ordinance, or I'm sorry, your charter, that I thought were specific, and some of these are covered actually in the enumeration of authorities that are in the statute. But you can adopt ordinances to regulate the collection of garbage, which is somewhat interesting. The construction and alteration of use of public buildings, firearms within the municipality, and pollution, interestingly.
Can I ask a question about that? So when we had a couple summers ago, a young man who stood on four corners almost every day with an automatic weapon. And we tried to find a way to remove him, or remove his weapon anyway, and we were not able to do that. So I am a little surprised to see that we can control firearms.
Well, you have the authority to, but we have not adopted any ordinances or any policies.
Well, we were looking to do one, and we talked with both Senators Sears and Campion at the time, and we were told that we could not do anything, that our hands were tied because it was only the legislature that could do something.
And I think that's true, because and Jim, you can correct me, but we can't adopt a law or an ordinance that violates or goes against the statutes of the state. Yes, they give us authority to look at things, but in that particular case, the right to bear arms is a right conferred by the state of Vermont.
So we could have gone through the process, but it would have been denied.
It may not have held up in court, and I'll look to Jim to that.
Yeah, and it's a really great question, because just because you have in your charter this subject matter that exists that would allow you to adopt an ordinance, that ordinance still needs to comply with people's individual rights to bear arms under the United States Constitution, as well as the doctrine of what's called preemption. So to the extent that the state has delegated to itself and has enacted laws that deal specifically with firearms and pretty much regulated the area, they have extensive, comprehensive regulations dealing with that particular subject matter. You are not able to adopt an ordinance. You are enabled to, but you're not able to get through a court process.
Not legal.
Yeah.
Not
With
enforceable?
your ordinance. If an officer, for instance, were to take your ordinance and go out and issue a citation, or take someone into custody, or do anything along those lines, or try to confiscate a firearm, it would be very difficult day in court. And yeah, so you have authority to adopt ordinances. They still need to meet all of the other requirements and issues that relate to any kind of local regulation. And that exists across the board, not only with regard to firearms, but anything else that you're regulating as well.
I have a follow-up question, Jim,
Yeah.
because it's a complaint that came into my office just this morning. Given that authority in the charter to regulate firearms, could we potentially regulate beyond what the state law says, the discharge of firearms, or the installation of firing ranges, or those kinds of things that aren't necessarily dealt with in the statute?
Yes and no. It would depend a lot on the facts and what your specific ordinance is regulating specifically. that goes beyond or adds another level to what already exists in the state statutes. Because there is, when you're dealing with preemption, the doctrine of preemption, which also exists at the federal level, too, to the extent that the federal level has regulated in this particular area. There's two levels of government that you have to deal with. And if it's really gone into the area and issued extensive regulations, a court just based on that alone can say they've regulated the area, and that's that. This is interesting because it would put the legislature itself in conflict, right? I mean, if it's delegated that authority to elsewhere within state government to deal with and enact regulations dealing with the discharge of firearms. But it's also put in your charter the authority for the town to do that. There's a conflict there. But, you know, before you, I think, acted in that particular area, I think it needs some very careful crafting of an ordinance and a very careful analysis of what other regulatory authority is out there that would deal with that particular issue and topic.
Thank you.
And sometimes, you know, municipalities, when they're dealing with problems, that, you know, they've got a problem and they want to move in that area to try to solve that particular problem. But sometimes the complexities of trying to do that or trying to accomplish that can basically put, you know, you in a position of having to defend that, not only in connection with whatever ordinance citation has been issued, but also a potential collateral claim against the municipality for having enacted an ordinance that basically infringes upon or potentially infringes upon someone's personal rights to bear arms, for instance.
So not only can we not enforce an ordinance, we might be liable for trying.
There's that potential for a collateral action to be filed. What's called a collateral action. So it's not specific to the event itself,
Yep.
It's a challenge to the statute.
Got it.
Yeah, but I noticed that as well. Okay. Junkyards, there's a specific, there's also a state statute dealing with junkyards, but I mean, I can tell you from my own experience, trying to regulate junkyards is an extremely complicated process. Very difficult to impose. You can always adopt an ordinance. I mean, there are model ordinances dealing with junkyards that can be adopted, but when it comes to the actual process of having the administration, storage job, take that ordinance and then put it into practice and actually effectuate, you know, the desired outcome from enforcing that ordinance, it can be enormously complicated. Not only from the standpoint of defining what is junk and what is not junk, but even if you get a court order saying, yes, that material needs to be cleaned up, site needs to be somehow taken care of, then taking the next step to actually execute on that order is usually left to the town to do, because under many circumstances, the property owner just doesn't have the wherewithal, doesn't have the ability to deal with whatever accumulation of things that have been deemed junk, and it falls basically to the town to then effectuate whatever cleanup might exist, with very little, if any, ability to collect the expense of accomplishing it. But sometimes that's what a town has to do to move forward and get some enforcement of its ordinances. But it is an extremely complicated, that's a real side trip there.
And I will say, Jim, that we have been relatively effective.
Good man,
In
Stuart, I
doing
gotta
that.
talk to you about that.
Well, yes, please do, but it's my staff that does the work.
Oh, that's great. That's great. There was an interesting, and I'm not 100% clear on it, but there's an interesting specific authority to regulate fire departments through a coordinating committee. Not clear exactly what that is, but I have a vague memory of there being.
Bennington is made up, or was made up prior to 1969 of 3 incorporated villages and the town.
Right.
In 1969, the village of Bennington and the town of Bennington merged. The village of North Bennington and Old Bennington did not. They voted not to merge or did not consider the question. I wasn't here then, oddly enough. But in so doing, the village fire department became the fire department of the town. And I think that's where this comes
That's where
from.
this came from?
Yes.
Okay. It seemed like it was something specifically put there to deal with the problem, a specific problem. So with all of that in mind, we were talking about the general plenary authority, if you will, to administer under your charter now really residing in the town manager. That's been conferred basically by your charter over to the town manager to take care of the day-to-day activities and report to you about what those day-to-day activities are and make sure you have the information you need to perform your function and your job by way of the chief legislative body for the town. And those are sort of specifically set out in the charter, so I don't know that we need to go through them unless you would like to do that. But he's the chief executive officer, basically, for the town. And your charter specifically now says that he performs all other duties of the town prescribed by charter or required by law or by resolution of the select board. So again, that plenary authority to act. All right. We talked about the recall petition already. I thought that was interesting. We also mentioned, this issue relating to the management form of government, which talks a little bit about the notion of the board retaining the authority, for instance, to initiate a proceeding in connection with the manager at that particular point in time to deal with issues of for cause. And that sort of brings up this question of the other type of authority that the select board is often asked to assume and to work with, and that is as a judge, as a judicial body, a quasi-judicial body. And there are various locations in the statutes where authority is conferred upon the board to conduct what amounts to a hearing process, where people's individual rights are at stake, potentially, either their property interests or their property rights, or highway, or employment, or other issues that the board is asked to then oversee and reach a determination and a decision about. And that engages the board as a quasi-judicial body. So you sort of flip from your legislative hat and you now are a judge. You're sitting basically as judge and jury to hear information and testimony provided by whatever interested parties are implicated by the hearing process. And if we were just for instance to choose employment as the issue that was at stake, an employee has been disciplined in some way, or their job terminated, or their pay adjusted in some particular or specific way that they don't like or appreciate. What is the union situation here?
We have two unions, Public Works and Police. And generally, the union contracts are crafted so that the initial appeal from a grievance at the lower level is to the manager.
Yeah.
And after the manager, it is to an arbitrator.
Perfect.
So that the select board is
Select
out
board's
of.
out of that. So to the extent that the employees that you're dealing with here are union, that's not an issue that's going to come before you. But non-union employees, I assume there's a personnel manual.
We do have a personnel manual, yes, we do.
And very often, select boards are sort of the last stop in a hearing process to determine whether whatever has been imposed on an employee should continue to exist or whether they go back to their job. In the public sector setting, towns are employers. So they employ people and they act as employees. There is a whole level of law that deals with the protection of public employees that doesn't necessarily exist for the protection of private employees, employees that work for corporate entities or other private employers, non-governmental employers. And that's basically because there are times, and it will depend upon the facts and circumstances, when an employee can demonstrate that they have a protected property interest in their job, in their employment, that whatever contract has been extended to them for their employment, or whatever policies and procedures are in place that would suggest that they have something other than an at-will employment, that they are really causal employees and can be only terminated for cause. That provides to them a protected property interest that is constitutionally protected under principles of due process. So in addition to whatever may exist in your employment manual about the protections and the steps to go through to determine whether someone should or should not be, let's just call it terminated, or on probation without pay, there are also levels of federal protections that exist as a matter of interpretation of the United States due process clause, procedural due process under the Fourth Amendment. So the court has determined that there are minimal requirements of due process that need to be met under those circumstances. And those minimal things usually include some notice, some advance notice of what the issue is or what the problem is, and an opportunity to defend themselves and have some form of a hearing before a final determination about that employee is made. So that's where you potentially step into a role here of being an adjudicator. And conceptually speaking, as judges, you are not supposed to be in a position of prejudging anything. You're supposed to be impartial. You're supposed to be the board that is there to hear both sides of the story and make a determination based on that. It's a 7-person board. That's a pretty tough thing for a 7-person board to do. I mean, think of the Supreme Court. You know, and you're all hearing facts. And what's important in that particular set of circumstances is that you have not involved yourself in whatever the employment process is before you've had an opportunity to hear it. Because having done that, you are now in a position basically of saying, well, you've gone outside the hearing process to gather other information, to bring other things into the evidentiary pool that weren't heard by the entire board, and which the individual in question here hasn't had an opportunity to hear and understand and defend themselves against. So in that particular context, it becomes really crucial that whatever steps are taken to assure that you are not getting involved in the day-to-day issues relating to a particular employee and individually remain that way. And that you don't, if you're in the process of hearing, well, we may be having to sit in a quasi-judicial capacity to hear a particular case, that you are not getting individually involved in that particular situation so that you can continue to do your role, which is to act impartially and without having investigated on your own whatever issues exist.
So can I ask, I mean, so we do the usual quasi-judicial hearings we do are vicious dog complaints,
Yep.
which are just awful.
Yep.
So if one of us turned out, to have a friend who knew a heck of a lot about this, and so we got an earful, do we recuse ourselves? What's the process if someone has gone outside those bounds, or one of us is curious and we go searching?
Yeah. My advice to anyone sitting on a select board is that if you get that feeling with a citizen approaching you, that whatever issue it is that they're wanting to put on your table and ask you about. And I know as elected officials, you want to be responsive and responsible to the people who are coming and talking to you. And I totally get that. But if you are getting the sense, and as soon as you get the sense that this may be some sort of a situation that would end up in front of me as a board member, you immediately need to make a choice, which is, am I going to preserve my ability to do that? Or am I going to take myself out of the process? Hear the complaint. Ultimately, if you're hearing a complaint because it's a dog issue or an employment issue or whatever, that's a complaint that presumably you would redirect to the chief executive officer of the town, or to the dog catcher, or to whoever it might happen to be. No, not necessarily.
It comes to us.
Yeah, well,
Once the vicious dog complaint is filed, yes, it comes to you.
It comes to us.
yeah, no, it does come to you, but what I'm saying is, in the initial approach of someone who's just coming to say, hey, redirect it. To say, I'm not in a position to really hear this right now, and it's important that I not hear this right now. What's important is that you take that information. I want you to report the information, but take it to the person who can help you deal with that problem. Because I may need to sit as a judge in connection with whatever issues are coming up, and then let Stewart or the dog catcher or whoever it is that's administratively responsible. And that's a really hard thing to do. I know that. It's very difficult when people are upset, clearly, and for whatever reason, and they're not feeling like they're getting a great response to be sloughed off to somebody else. But that is the appropriate step to take, just from the standpoint of being sure that there's a level playing field at the point in time when people are coming to have their arguments before you about it, number one. And number two, that you're not exposing yourself or the town to some sort of claim of a conflict because of either prejudging or you've gone outside the parameters of the hearing and gathered and received information. If that does happen, and it's bound to, as soon as you can stop that process and do the best you can to explain it, the better, number one. And then number two, when you get to the hearing process itself, it's important that you put on the record, and before the hearing actually starts, that in fact I was approached. I want everybody to know, all sides, both the board members and the parties, that I was approached, had a brief conversation. I don't believe, or I do believe, that it takes me out of running or contention with being able to sit and hear this particular case, and you can decide whether to recuse yourself or not. And we can go through the conflict of interest policy, which you have, which is a good one in here. But when you're dealing with yourselves as a quasi-judicial body, that conflict of interest policy becomes really important. Not that it's not important in the legislative context, because it is, but when you're dealing with adjudications, and they deal with dog bites, or they deal with, if you're a DRB, with permitting, or any employment, you're dealing with a job. Depending upon how you act and how you respond to those situations, you can either keep yourself out of or make yourself a party to a case, again, in another collateral action. So, for instance, if a hearing occurs and goes forward and it is later determined that there were all kinds of ex parte communications on the part of board members who then sat and heard this particular case, you've probably just added a count to a complaint to be filed in federal or state court, basically saying that in addition to suing the town, I want to sue that board member, in addition to suing the town. So it does create some potential exposures for both yourself and the town, which is not something to be fearful of necessarily, but just so that you know in advance and have an awareness that I've got a job to do, and I swore to do the job. When I took my oath, that's what I got to do, and that's my role in this. The role of prosecuting it or pursuing it is probably most often going to fall to Stuart. That's the person who would come before you, basically, and present whatever information it is that would justify what Stuart believes to be the appropriate action to have taken, or the dog catcher, or the zoning administrator, or whoever the official is that's kind of responsible for overseeing that. Does that all make sense? I feel like I'm just yammering. Is that true, Stuart?
You're doing a great job,
All
though.
right, good. Yes.
Hi, our town charter gives the select board the power, the authority, to look into town departments, and I don't have the charter in front of me to say if it looks into town employees. So if citizens are coming forward with clear-cut evidence that something needs to be addressed, then that's something that the board needs to take up because that's our authority, rather than passing it on to the town manager, is it not?
I think it's going to depend on circumstances. If you're dealing with an employment situation and an employee issue within a particular department, or that's the issue or the problem, I would say that is something that ought to get referred to Stuart, to the town manager, whoever that might happen to be.
But that's not what the charter says.
Well, the charter does say, and I think I know the provision that you're talking about, that you have the authority to conduct your own investigations.
As a board.
Yeah, as a board. I agree with you on
Okay.
that. But I would say that those investigations, that what it's really talking about, and I would think that a court would interpret to mean investigations for the purposes of enacting legislation or policies or other things that are specific to the powers and authorities that exist in your bailiwick. So you can conduct investigations, we think this ought to change, or this ought to change, or the department ought to be run, in a more macro sense in a particular way. If it is an investigation, and we're talking in general terms here, we're not talking about anything specific, but in general terms, if the investigation is, I don't think, as a board member, for instance, that a particular individual is doing their job well, or fulfilling the obligations of their job, or running a department effectively, or it's an issue that relates specifically to the conduct and actions and activities of an employee. I think that's something that ought to get referred, in my mind, based on your charter, to the town manager for whatever specific action as the chief executive officer, or to the supervisor. There may be a supervisor involved too, I don't know what level we're at, for that action to be taken. And the reason I think that's important for you as someone sitting on a legislative body is that you may be asked to sit on a judicial body and hear and determine whatever issues that may crop up as a result of some actions or activities based on that referral that the supervisor is actually taking in connection with that. It makes it difficult, I think, to sit, having investigated something, and then to sit as a judge in determining whether or not, in connection with a particular individual or some specific action that's going to be taken, ought to be taken. It just makes it difficult to do that. That's my take on it, but I'm talking, globally here. I'm not talking about a specific situation. But I think that, given the way your charter is structured and the way the statutes are structured, that's kind of the intent of what they're looking to put into place. Is, the best way to get through the process, and these processes can be really long. I've dealt with I don't know how many employment situations in the public sector, both in terms of the internal process and in terms of dealing with the collateral lawsuit that very often either follows or is going on concurrently. They can take years to winnow their way through the process and wind down. But it's really important that the town have provided the due process to whoever that individual is in the employment context, because that really reduces Well, for a couple of reasons. Number one, it's fair, and number two, it really reduces the exposure of the town to be able to go to court and say, we provided these are the steps that we provided all the way through the process, and we stayed in our lane, and we did our role, which is to make a decision. But I do think that there's certainly more than a suggestion of authority here to investigate things for the purposes of enacting your policies and ordinances and procedures. I do think that exists.
A follow-up to that? So if the process is followed and accusations are made and they are referred to town manager and our attorney, and what comes back is a finding that there is no fault and the accusations are false, then is that the end of it? Or,
Well, so what I'm hearing is that, and again, just to put some context to it, we're dealing with an employee, public employee, who has gone up through the step process to now finally appear before the select board for the purposes of conducting a hearing. No? Do I get this wrong?
Yeah, our charter throws what Nancy is talking about somewhat into conflict because it specifically gives the manager exclusive authority over employees. So that it does run somewhat contrary to what it gives the authority on the board's right to investigate.
Okay, so I hear that the charter gives you the exclusive authority. And in my mind, what that means is that you have the exclusive authority to deal with employment issues, basically.
I take it that way, yes.
Yeah. But that doesn't necessarily comport with all the obligations and requirements of due process, potentially for the
That's true.
purposes of dealing with a particular individual. And I don't know, because I haven't read, and probably should have before I came, your personnel manual or book to know whether or not there's a progressive disciplinary process.
There is.
And does that progressive disciplinary process involve the select board?
I don't believe it does. I believe it follows along the lines of our union agreements, which takes it to mediation and arbitration.
Okay, all right. So
That also would not be relevant in the example that I think that my co-board members are getting at. If there was an accusation of impropriety made by the public of an individual employee, and that those questions were then forwarded to the town manager, and the town manager and his staff completed an investigation that led them to believe that there was no impropriety, and they've reported that back to the select board. Jeannie's question to you was, is that the end of it?
I would say yes.
Thank you.
Can I just ask a clarifying question? When you were talking about doing an investigation, did you mean as a board or as an individual member of the select board?
Well, I take it would be whoever is delegated by the board to conduct whatever sort of investigation. And when I say investigation, a lot of times boards are appointing, and we sort of need to get that, but they're appointing advisory committees. Go out and research and find information about a particular thing to determine whether we should adopt an ordinance and what the ordinance should look like, for instance. Or to find out if there really is a problem or there really isn't a problem. That sort of thing where a committee basically is being set up
Okay.
to look into or investigate. They would have the delegated authority from the board to do that.
Okay.
But the authority that's conferred by the charter is authority that's conferred upon the board,
Okay.
not necessarily individual members.
Right.
Right, so I'm thinking, so we've had quite a few 3-member subcommittees that go off and research something for policy, come back and say,
Make a recommendation.
here's what we recommend to the board, and then as a full board, we vote for it.
Right.
Exactly.
Yeah, I'm thinking about our
Yeah,
public
and as a
comment.
3-member board, I mean, you have a 7-member board. You know, they don't have any authority to enact anything, really.
Right.
They have to come back and get, I mean, it's clear, I'm sure, to everybody that you cannot act except for getting a majority of the board to act. You can't act unilaterally or individually. It needs to be joint authority given to 3 or more, needs to be a majority. Sure needs.
If there was a step that the board has to take by law, state or federal law requires, and the board skips that step, what happens then? You know what I'm saying?
Can you give an example? Yeah.
I'm just trying to think
If
before.
we're receiving money, federal money.
Yeah.
And as a board, we have to vote to accept that money. And the vote never happened. And citizens are questioning, why didn't that vote happen? What happens then?
Well, if in fact there is some requirement as a result of the grant or whatever it might happen to be, that the town formally accept, presumably by filing an application for a grant, they've indicated interest in taking and accepting whatever the funds are. So I don't, I wouldn't know about the particulars of any particular grant and whether a formal acceptance is or is not required in connection with that grant process. That would be something I think I want to look into, because I think from an administrative standpoint, that's more an administration issue. If the board has already decided to move ahead and seek and obtain some sort of a formal grant, was this approved at a board level?
In order to get this big chunk of money,
Yeah.
the law requires that the board formally vote to accept it.
Uh-huh.
And if the board never voted to accept it, and citizens are saying, wait a minute, federal law requires you to do this,
Yeah.
and federal law requires you all to bid to use this money. If those two things aren't happening, and citizens are taking the time to research and they're proving this to us, what do we do then?
I would bring that specifically to the town manager, to the executive, and say we need to do this, it needs to get put on the agenda. But again, that's a matter of reading the fine print in whatever document it is or whatever grant it is that you're thinking is missing some essential step for taking that particular grant.
And if I could tell you that every grant application is voted on by this board, and typically that fine print would give the authority to the town to receive the money.
Yeah, I can't speak specifically to particular grants but it seems that, it seems to me that could be taken care of just by way, and if a formal opinion from the town attorney is required in some way, that might be a way to resolve it, or take care of the problem as well. How we doing?
We're doing all right.
This is really helpful.
It's helpful for me too. This, I gotta say, I really enjoyed reading your charter. It's like, wow. These people are pretty good. And you gotta get together every 5 years to have another look at it.
Yeah, we're just starting that process.
Tomorrow night or Wednesday night.
Wow, that's great.
So just to clarify the answer on the last question that Nancy asked, it was kind of an open-ended. So what happens? So a board member who believes that the town is violating its own policies or federal or state policies would bring that question publicly back to the board and likely to the municipal attorney to determine if that violation has occurred.
Yeah, that's what I would suggest, for sure.
Okay.
Let's get the grant out. Let's have a look. This is something that there should be an answer to.
Yep, most likely there is.
We want the money, we soon want to make sure we have it.
Yeah, exactly. Yeah, that makes perfect sense to me. All right. It looks to me like you've adopted policies and procedures for just running your board meetings.
We have not, we're in the process of reading, we've done a first reading on
Yeah.
procedures for, and they are basically the VLCT template.
Yeah, I saw the proposed draft.
Yeah.
Is there not another policies and procedures that is in
There-
place or no?
There is an initial policies and procedures that I think comes out of the Tom
Yeah,
Jacobs era.
It's a lot,
Yeah.
it's a lot thinner,
Yes, yes, it is.
I would say, but it hits all the high points as to how to run and operate a meeting and operate it effectively. I think the proposed draft you have is far more detailed and will answer a lot more of the questions that might come up over the policies and procedures to be followed during a meeting process itself. And so I don't know that we necessarily, unless you would like to, need to get into that, because I think the process that you've laid out here with providing opportunities and limits on the amount of minutes and, so that you can get your business done, but provide an opportunity for the public to address you as a board, get off their chest what needs to be gotten off their chest. And that's an important function. It's a really vitally important function that happens. But it seemed like it was well crafted, and I agree it sort of follows the model policies set up by the league. So I'm all in favor of those. I think it might be worth talking a little bit, and by the way, there's a new act that just came down the pike. I think, Stuart, you may have alluded to it when we were on the phone, dealing with the open meetings law. So your meetings, including this one, is subject to the open meetings law, and there needs to be notice and an opportunity to be heard. Decisions and motions need to be made in public and voted on in public. There needs to be agendas, there needs to be minutes, there needs to be retention of documents and information pertaining to your actions and activities. All of that is pretty well spelled out in the statute, which is part of your materials now, as to what to do and how to do it. The issues that come up most often for me in the towns that I represent deal with executive session, the do's and don'ts of how to deal with executive session, how to get in, how to get out, what you can talk about, what you can't talk about, and what you can do about executive session, and when is it appropriate to go into executive session. So maybe if we talk about that a little bit. So Section 313 of Title I deals with the only reasons for which you can go into executive session. Otherwise, all of your business is conducted in open, with the public able to be present and to hear your conversation and hear what you have to say. The issues that most often come up with me dealing with executive session, because I do a lot of litigation, have to do with either employment issues or pending litigation or threatened litigation, or other reasons for which the board is looking to confer with their attorney and to get some advice from their attorney about a particular issue that's pending before the board and before the town. Those most often seem to be the flashpoints when it comes to executive session and how to deal with an executive session. And there are exemptions from the open meetings requirements dealing with each of those topics, but they are limited. When you're dealing, for instance, with pending litigation or threatened litigation, or seeking the advice of counsel, there's a requirement that you engage in a two-step process to get into your executive session. So first of all, a majority of you has to vote to go into executive session. So there has to be a motion put on the table, and it would typically be included in your agenda as possible executive session to deal with a particular issue. You would then need to hold formally a vote. And that two-step process asks that the board clearly indicate by motion that discussing this particular matter in open would clearly place the town, the municipality, or the body, you, the select board, or some other individual at a substantial disadvantage. So that having this conversation in public could potentially expose the town, could reveal conversations about, for instance, options to purchase property, for negotiations that are going on in connection with that. It could expose the town to liability and exposure based upon information that's being exchanged, in particular when you're dealing with an attorney or talking with an attorney. It's really important that attorneys understand both the good information and the bad information about any particular issue that might be coming up for which there's a claim that's been filed or is potentially being filed. And the only way to get that out into the open and to clearly understand so that everybody can make good decisions when they come out of executive session is to make sure that there's clarity and that the attorneys and that the people are free to speak about both the good information and potentially bad information, or information that might be detrimental to the town's interests in the course of a particular conversation, so that good decisions can be made on the town's behalf and in the town's interest in total. So you need to have identified not necessarily specifically what it is, but that based either on the advice of counsel or for a reason that it would clearly place somebody at a potential disadvantage, including the town, to have those conversations in open public. Now, from my standpoint as an attorney, when you are dealing with a lawyer and seeking a lawyer's advice, it will always place the town at a disadvantage if you are seeking specific advice, which may be good advice, or may be advice that you like, but it may be advice that you don't like. It will always, almost always, I can't think of a time when I've been asked to provide advice to a board in total, not just the town manager, for instance, as the chief executive, but it's time to go to the board, have a conversation with the board about this, and bring them up to speed. And here are the tactical issues we have to decide and address. Here are the potential exposures for the town that we might need to deal with and address. Here are some of the facts that might drive some of those exposures. That's information that, if revealed in advance from the standpoint of the town's interests, is going to place the town at a substantial disadvantage. So from my standpoint, if I'm being asked to come sit with a board and have a conversation about a pending matter or a matter that may be coming up, I am always advising a town, almost always, unless it's really just pro forma. We got a hearing coming up next week, or process sorts of things. But if they're asking my legal advice in connection with a particular matter, that's something that, in my mind, this board has an opportunity and should have an opportunity to hear directly from the attorney, with the attorney feeling free to speak.
I'm confident when I say this, that the vast majority of our executive sessions do not require our attorney to be present.
Yeah.
And it's my understanding that those need to be taken just as seriously as the executive sessions where our attorney happens to be present, and that we also can be held individually liable if something goes awry during an executive session. Is that not true?
So let's talk a little bit about that. But just to wrap up what I was talking about, you need to have this two-part
We do
motion.
that.
And you do that.
Oh, we do that.
Yeah, so you're all set on that.
Absolutely.
Good. So having gotten into executive session at that particular point in time, my practice with the boards that I represent is that there shouldn't be any recording of it.
There is none.
No minutes taken. It is an opportunity for people to speak, really. So everybody gets in the room, a conversation is had. The conversation is had only about the topic for which you went into executive session. It should not drift. And if an attorney's not present to see that it doesn't drift, you want to make sure it doesn't drift into other areas. It should only be about the topic for which you went into executive session. And if in a particular meeting you have multiple issues for which you're going to be going into executive session, my advice to the towns I represent is to do it one at a time. Don't bundle them, do it one at a time. So what I mean is
Go in
we're
and out,
going
in and out,
into
in and out.
executive session, the general topic is X, just do the one topic. Don't do topic X, Y, and Z, we'll go into executive
So if we
session.
have a legal and a contract matter, then we would come out of executive session, we would do legal, come out of executive session,
And go back
then go
in.
back in.
Revote.
for Contract.
Go in for the contract.
And what if there's no vote? So we generally do not vote at the end.
You're voting to go in and out of session, that's
Oh,
all.
yeah.
Yeah, so, and that's also important. So when you go into executive session and there's no action taken, it's, it's advisory, it's for the purposes of rendering advice, for maybe the attorney maybe getting some direction, maybe not getting some direction. But in those circumstances where no action's being taken, you come out and you just put on the record, no action taken.
Yeah, that's what we do.
And that's, and there's the end of your executive session.
But we don't have to make Jim wait out in the hall and record us coming out of executive session, going back in.
You don't unless Jim, unless Jim is like, Jim, what do you say, buddy? You wanna go home? That would be something that I expect might be put in the agenda. It might say possible executive session to discuss, again, general topic.
Generally, go ahead.
Yeah, I was gonna say, we put executive session and we say legal, comma, contract.
Yeah, okay,
Yeah.
all right.
And we generally go in and we do legal.
Yeah.
And then we finish that conversation, and then we do contract.
Yeah, I think that's, I think that probably covers it. Some towns are a little bit more specific, legal matter of da-da-da-da-da, whatever the title of the litigation is. But, I don't know that that's a necessity.
Okay.
And we also, you will announce before we even go in that no action will be taken.
Yeah.
Yeah.
Well, if
Ahead
that's
of
the
time.
case, then you certainly don't want to come out and take any action.
Exactly.
But that does allow people to go home.
Yes, it
Right.
does, absolutely.
Right.
And that's only fair and appropriate. Yeah, absolutely. So while you're in executive session, and not drifting from the topic is important. I do think it's a good idea to go out, come back, go out, come back for whatever the issues are. So there's clarity around what you've done. No notes being taken. It is important whether a lawyer is present or not, as you're saying, to treat executive session just like you do open session. From the standpoint of being careful about what you say and how you say it. And the reason for that is executive session is not a privilege. It's not an evidentiary privilege. What it is an exception, a statutory exception that allows you to meet outside of the hearing of the public. And that's pretty much all it is. So when you go into executive session, you're legally in executive session. You can discuss the topic for which you went in as long as it meets one of the exemptions. And you've limited your conversation to that. But it does not necessarily mean that everything that is said in that executive session won't end up with you on a stand having to testify about what happened during the executive session. And the reason is there is no evidentiary privilege in a court of law that exists because you went in for some sort of executive session. That just allows you to meet outside the confines of the public. It doesn't
Shield us from anything else.
from having to testify either at a deposition or in court or otherwise provide answers necessarily about what happens. Now, that's particularly the case if you go into executive session and you don't have an attorney present. If you have an attorney present, there is a privilege. And the privilege is the attorney-client privilege. And that's an evidentiary privilege. That's a privilege that it's a rule of evidence that exists that prevents persons from forcing you as a board member to testify or say about what happened in your conversations when you were receiving professional advice from an attorney. So that is a privilege that can be used. So if, for instance, there are some concerns, sometimes it is appropriate to have an attorney present, particularly if you're talking about litigation, if you're talking about something you know is in a court process. And you are entitled as a board, you are a client of that lawyer. If the town entity is being sued, it's one of the defendants in the litany of defendants that have been sued. You are the client. So lawyers are having conversations with you as a group, as a client. And you're entitled to have those conversations and have that privilege exist in connection with those conversations. So if it's a matter that you think deals with liability or exposure or any of those sorts of potentials, sometimes having an attorney present, particularly if you are looking for their advice. I mean, really, if you're looking for their advice, because that's when it's effective. There is a privilege for that. Nonetheless, executive session is not an opportunity to just blow off steam. It really isn't. It's got to be very specific to the topic at hand, get the information that is important material that matters in terms of your future ability to make decisions on behalf of the town, and get out. And just be as careful in the executive session about what you say as you would be in the public.
Can I just say one thing?
Yeah.
I think we all know, but I'm just going to say it out loud. The reason there's no note-taking, the reason there's no minutes, the reason there's no audio or video is to maintain confidentiality. Ultimately, yes.
Yes.
In addition to us not blabbing.
Yeah. It is. Basically, there's just no requirement to be taking notes during an executive session. You can almost consider it's not technically deliberation, but it is very much like that. It's basically, you are an entity, whether you like it or not. You are bound to each other to work on behalf of the town and ultimately make a decision based on the majority of you. And it's your commitment to one another to keep that. And to basically keep those communications among yourselves, because that's why you went into executive and you voted to go into executive session in the first place. Now, when it comes to anybody, unilaterally discussing what happens in executive session, that's a really bad idea. And it's a really big, mostly because it's not your place, it's not your right or privilege, it's the board's. So if the board decides, well, okay, let's reveal what we discussed in executive session, you can do that. You can take a vote and talk about what happened in executive session if you choose to do that. But it's the boards, not the individuals, not any of you individually. And the same is true of the privilege. So to the extent that you're having attorney-client communications with an attorney, that privilege doesn't belong to you individually. That privilege belongs to you as a board. And really should not be waived unless I, as your attorney, if I'm representing you, get the approval of a majority of you to go ahead and reveal whatever that communication was. I'm not going to go reveal it because you, Ed, did I get that right?
You did, yeah.
Said, go ahead. Talk about it. That might be one of the reasons we're meeting in executive session. Is I got to know whether I could, there may be sometimes reasons to reveal a communication between an attorney and a town board. But I can't do that unless I have a clear understanding from the board that I'm authorized to do that, in which case I'm going to want you to come out of executive session and vote to authorize that to happen. So those are, and a good reason, another good reason to do it is to reduce the potential of collateral liability and exposure to the town. And this also applies in connection with whether you're in or out of executive session, pending litigation, or litigation that you're relatively certain, or that your town manager or your legal counsel has said, you know, I think we're gonna get, it looks, there's a claim coming down the pike. As soon as that happens, and again, this is a really difficult thing because constituents are coming up to you, and they wanna know information, they wanna know what's going on. And they've heard about a claim, and it's in the paper, and it's on PEG TV. Jim over here has got it on TV, and they're, oh my gosh, what's going on? If there's pending litigation, typically, the less said, the better. Because anything, for two reasons. One is that you individually are not speaking on behalf of the board. So to the extent that you're having individual conversations about things, it's just you having conversations. It's not the board. You're not authorized to speak unless you are authorized to speak on behalf of the board. So for that reason, it's important. And the other is, you can create evidence. It may be good evidence, it may be bad evidence. But when a board member speaks about pending litigation, and we're at the very beginning stages of discovery, we don't know where this is going, we haven't talked, we haven't investigated anything. When you start talking without the benefit of all that information, you have no idea whether what you're saying is accurate, is true, ultimately, or will be proven to be true or disproven to be true. And there's the potential to create more exposure than you're solving. Not only for the town, but yourself, individually, as well. So typically, the advice from council is we cannot talk about or address pending litigation as much as we would like to provide the public with an understanding of what the justification of the action of the town was. I mean, a lot of times, towns are dealing with litigation with one hand tied behind their back because their lawyers are telling them, shut up, don't talk about this until such time, at least, you'll get your, believe me, you will have an opportunity, to be deposed and to provide the story. But it's probably going to have to wait. It's probably going to have to wait a while before that happens. And a lot of times that's happening in the face of people who have complaints about the town talking a lot about their side of the story. So sometimes it can be difficult to do that because you've got your side of the story. But it may not be the appropriate time to put that on the record or to be talking about it because all the information hasn't necessarily been gathered at that particular point in time. So anyway, that's my little speech on speechifying on pending litigation and being careful about what you say. That kind of leads into this very interesting, you folks are looking at adopting very interesting stuff, the media policy, social media policy.
Should we take a 5-minute break?
Sure.
Okay, let's take a quick break.
Yeah.
So
How much more time we got, Stuart?
Well, it's 7:10.
we're over, but I think we do want to hear this, and I definitely have a question about voting that I want to make sure that I get a chance to ask.
Social media policy.
So yeah, I think that was, if I'm looking through my notes here, one way or the other, I think we hit on most of everything else.
Can I ask a question about voting?
Sure.
So, just because we've gotten a lot of feedback over Cat TV, Facebook, and emails and people stopping. So when we take votes, we can vote yay, nay, or we can abstain. We've started having everybody raise their hands because I think in the public was getting a lot of comments about we can't really tell how people are voting. But a follow-up question from folks has been, if we're all present, we're all part of a conversation, if someone decides to abstain from voting after we've all been part of the conversation, is there an etiquette around saying, I'm going to abstain because of X? Or is it, the VLCT model procedure did not include anything about that. So I wasn't sure what general protocol on that might be.
So the protocol around someone deciding after a conversation, so a motion's been put on the floor, it's been open, the board's been allowed to ask the questions, and the public has been allowed to chime in, and so a board member at that point, the question gets called, and you're going around, or you're basically doing hand votes at this point?
Yeah,
More or less?
yay,
Yay,
nay,
yeah.
abstention.
And then an abstention, and is the question whether the individual who is abstaining should put on the record the reason for their abstention? Is that the?
Yeah, is there a best practice? I've had members of the public say, if someone's taken part in a discussion, why are they abstaining? I mean, if they come in, sometimes they'll come in and say, I missed the last meeting, I don't feel comfortable voting on this. Okay.
Or this particular agenda item is one that I'd like to recuse from, and then they don't participate in the discussion. We understand that. Well, I think what Jeannie's referring to is someone who's actively participated, and we didn't expect them to abstain from the vote, and then they did, and we don't understand why.
Yeah. I don't know of any basis upon which to insist that someone who abstains state the purpose and reason for their abstention.
Mhm.
There's no obligation, statutory obligation that I'm aware of that would require them to do that. I'm not even sure under Robert's rules or other rules that it's necessary for that to happen. They should put on the record that they are abstaining so that there's clarity around why the vote is the way the vote is.
Sure. Yeah.
I don't know that they necessarily need to do that. If there are concerns that someone's doing that and gee, I'd really like to know what the heck you're abstaining for, or practice is being made of it, presumably the voters the next time around would, so why am I voting?
Yeah, that answers my question. We don't have
every vote.
Yeah.
We don't have an obligation to record a reason for an abstention.
No,
That
it ought
answers
to be
my question.
reported that an abstention has happened.
Oh, absolutely. Okay.
I'm not aware of any obligation to
Okay.
inform the public as to why that's occurring. But it does sort of get to the corollary question about a conflict of interest, right? And whether or not an individual, and under your conflict of interest policy, whether an individual, for instance, can be forced to abstain.
Yeah.
Or to recuse themselves, which, by law can't really happen based upon an executive official. There are other steps that can be taken that are actually well spelled out, I think, in your footnotes. Your footnotes tell it all in the conflict of interest policy. I don't know ultimately that with an elected official that's been voted into office for a 3-year term, he can't really do too much other than sanction them or hold a hearing. But if someone is conflicted or asserting, I really shouldn't vote on this, a matter of practice is they really should get up and move from where you're sitting. They should get out.
Before the discussion happens,
Well,
or during the discussion.
if at any point in time in the process, it would be good if, usually when a topic gets put on the table, and particularly in a quasi-judicial setting, when a topic gets put on the table and someone is feeling uncomfortable, or another board member is potentially feeling uncomfortable about a board member sitting, that topic should get raised right up front.
And we do
Yeah,
have
yeah.
a statement at the bottom of
Yeah.
our agenda
Yeah,
that says to please inform.
as early as possible.
Yeah.
It may be that there are times when it's like, oh my God, I gotta get out of this, because the conversation's going on, it's like, oh man, no,
Now I have a
Or
conflict.
now I know who that person is, or, you know, the bell goes off, or the recognition goes off. But as soon as that happens and someone's feeling uncomfortable, they should put that on the record and get out. And go sit in the audience.
Okay, thank you.
Here's a question for you, as a follow-up question. Here's an example. Town manager is sharing with the board activity that he is involved with, and this board has no oversight of that particular item, and he's sharing for informational purposes only. If this board were ever to need to take any action, and a particular board member felt a recusal was necessary, we understand that. In the exchange of information, isn't a recusal necessary? Or because there's no action being taken, there's no recusal necessary?
Yeah.
Am I making sense?
I think really the conflict of interest issues come up, particularly in a legislative context, when you're acting in a legislative, as soon as a motion
Gotcha. Thank you.
happens, that,
Yep.
that should be a signal. And certainly if you're in a quasi judicial process at the initiation of the proceeding.
Understood. That answers my question. Thank
Yeah.
you.
Yeah, so this social media policy, I think is a really great idea. It's the first one I've seen. Stuart, are there others?
The police department has one.
Our police department has one, but yeah, I think
I've never seen one.
we may be,
Jonas said he explored other communities, so.
yeah,
I think
there may be others, but I'm,
What it really does is it brings up two things, and then I'll let you all go home. Sorry to take up more of your time.
No, this is-
Very valuable.
So, two things. One is getting back to the topic of none of you individually speak for the board without the authority of the board to speak in an official capacity. And this case is interesting, this Freed case. It just got decided in March. And it raised the question and the issue of the town manager who, had Facebook, a social media platform. And on that platform, he was using it for personal reasons, all kinds of, my family does this, my family does that. But also from time to time, and more than time to time, also discussing political issues that are coming up before the board, or, giving information. So a lot of times it's informative type stuff. Sometimes I think it appeared from the opinion that there might have been an opinion that was in there from time to time, and people were remarking. People were throwing comments on, and he had an open Facebook page that allowed that to happen. Well, someone starts throwing in comments that he doesn't like, or he thinks are abusive, and boom, he shuts it down as to that particular individual, and he gets sued, as does the town, for violating First Amendment rights. Someone's right to speak on a public forum. So the big question that the court needed to address was, is this gentleman's Facebook a public forum? Does it exist as a public forum? If so, is he authorized or delegated by the board to speak on that public forum? And it's a state action case, is really what it amounts to. So it's actually quite specific to the statute that the suit was brought under. And the statute is called 1983, 42 U.S.C. section 1983. And you'll hear from time to time that someone's brought a 1983 claim. And a 1983 claim is a claim that's brought by an individual who claims that through state action, through some action or activity of a public entity, either an individual or a board or whatever, that their rights have been violated, their constitutional rights have been violated, and or statutory rights have been violated. And what it did is it gave damages, it gave people the ability to seek monetary damages as well as injunctive relief and other forms of relief if they successfully allege that a municipality has violated their constitutional rights. And it's like a tort claim. It's like personal injury tort claim, but it's in a federal context usually, and it has everything to do with violation of an individual's rights, either under the First Amendment to due process, we talked about that earlier. Police cases, those are the cases that get brought under Section 1983, basically, where allegations are being made that police officers have violated their rights by either using excessive force in connection with detention or detaining at all, or not giving, Miranda rights, all of the different protections that apply when officers detain or take someone into custody. Municipalities are hugely exposed to 1983 claims. A lot of claims get filed throughout the country using this Section 1983. This is one of those claims. So the claim here is my First Amendment rights were violated because this gentleman, who's the town manager of this particular town, had a public forum. I believe it was a public forum. It was being operated. People were allowed to comment. He was commenting, and then he shut it down. And I have a right, a First Amendment right, to speak in a public forum, unless there's very narrowly tailored time, space, type limitations on your First Amendment rights to speak. That was the allegation. What the court basically found is there was no state action. And 1983 requires that the entity, the public entity, act in some way to violate your rights. Not individuals, but the public entity or someone authorized or designated to speak or act on behalf of that entity. So what the court basically said was, this particular Facebook, this social media account, they didn't buy that social media account was a public forum, basically, or had been created and sanctioned by the town. And basically the reason for that is that the board never gave him authority to do that. So he was just off kind of doing it on his own and also using it for his personal purposes. So they just didn't buy that argument, which isn't to say under other circumstances that they could buy the argument. And the other aspect of this that was interesting that they really looked into was what does it take to basically have a municipality enable someone to speak. That's the first thing that has to happen. So if you're just unilaterally going off and speaking, you don't have any authority to act on behalf of the municipality. But if that authority has been delegated to you and you're starting to talk and you're putting it on a public forum, now you're creating exposure. So the concept here of having a social media policy, I think, is a really good one to make sure that people, because people also have the right to speak. And that's the other thing that this case was dealing with, is that this town manager had the right. He has a First Amendment right too. And he was using this particular vehicle for the purposes of doing that, but in a private way. So he could shut it down just like anybody else can shut down their account. That's more or less the holding that they came to, but they left the door open for circumstances where, depending on the facts, state action might actually be a problem. And so you just want to be very careful of it when you are speaking publicly. You have a perfect right to do that, and you, in fact, are kind of elected to do that, right? I mean, you're politicians, after all, in a very local way, in a very local setting, but you have the right to speak and to put it out there and to engage it. And to state your reasons for doing that, but you've got to clearly indicate that I am speaking on my own behalf as an individual. I'm not speaking on behalf, and I'm not authorized to be making these comments by the board on which I sit. Or if you're an employee, by my supervisors and employers. So I think having that is a really good thing. One other thing, and then I'll let you go. Under Section 1983, unlike tort claims, where if you're an agent of a municipality and you do something that injures somebody in some way, in a negligent way, if you are acting within the scope of your authority, you have now bound the employer as well as the employee. So there's what's called respondeat superior liability. So if you send someone off on the highway department to do something, and they're acting within the scope of their authority in doing it, and they're engaged in doing it, and they do something negligent that a jury thinks created or caused some liability and exposure, not only is the individual liable, but the employer can be liable as well. That's respondeat superior liability. In Section 1983, that is not the case. So they call these federal tort claims, but the Supreme Court, which basically created most of this exposure out of 1983, in good ways, mind you. I mean, the people do need protection from us from time to time, for sure. But the Supreme Court has basically said, if an agent goes out, if a police officer, for a fireman, zoning administrator, or whoever, goes off and does something that violates someone's constitutional rights in some way, infringes their First Amendment rights, or does something else along those lines, the employer is not liable under theories of respondeat superior. So it's up to the plaintiff to prove that somehow the employer, the town itself, was involved directly in the tort, in the claim that's being made, in the infringement of the constitutional right. So they have to basically demonstrate or prove, and the way that happens is basically to say, well, we have in effect sanctioned what this person's done because this person's done it a whole bunch of times and we haven't disciplined them, we haven't trained them, we haven't seen to it that they aren't engaging in this activity. And it's repeatedly happened over a period of time, and you can make out a case against the town under those circumstances. You can also make out a case if in some way you ratify the decision. So to the extent that any of you are individually going off and, for instance, making statements about an officer who did something that in the hearts and minds of a plaintiff think that that statement is sort of ratifying that activity, that starts to create exposure for the municipality, in addition to the individual. So just another reason why the less said typically the better, under those sorts of circumstances. That's pretty much what I'm going to say.
Very, very helpful. Any final questions?
Some board members may have some questions.
Yeah.
I've asked
Any
mine.
other questions?
I do.
Okay.
Go for it.
7 of us are elected to serve, when up to 3 members of the select board are allowed to meet publicly with the town manager and maybe others, and the majority of the board, the other 4, aren't allowed to be there, don't know what's being discussed or said. When did this become legal in Vermont? I mean, I understand the quorum and the reason for that, but I'm looking at the reverse that has been happening.
Yeah, I don't know that I'm in a position to comment on any specific action or conduct that occurred. To the extent that you are a board member, you certainly have the right to speak directly with the town manager.
I'm talking.
Or with the
whether
chair.
it's, say,
Can we
there's 5
clarify, Nancy? Can we just, I mean, can I just give him you want to give the
Well,
example that you're
sure, but
thinking
I'm just
about?
saying, if there are 7 people elected to serve,
Yeah.
and we are the supervisor employer of the town manager, we all need to know what's going on. When up to 3 people on the select board are being allowed to meet with the town manager, other town officials, and other people at the meetings, how can 4 of us do our job and be involved?
Is
if we're-
that an executive committee of some sort?
I have no idea what you're talking
I
about,
think
except
I know
that I
exactly
think.
what
I think
she's
it
talking
refers to our meetings with
SVSU
the
select
superintendent.
board.
Oh, with the we have, maybe 20 years ago, the chair of the supervisory union in town put in place an occasional meeting between staff at the town, staff.
Generally, the manager, the assistant manager, the superintendent, the assistant superintendent, superintendent of the
Tech center.
Southwest Tech Center, and perhaps his or her assistant, and at least 3 board members from the select board.
Not
3
at
board
least, no
members from
more
the
than.
school
No
board.
more than.
No
No more
more than.
So is this,
It's-
And it's a first come, first serve.
That's
It's not a,
That's
it's,
the key. First
it's
come,
not
first serve.
it's not a standing committee. It is a first come, first serve.
So the invite is put out that there's a meeting scheduled with the supervisory union. Who would like to attend? Up to 3 people. 3 people raise their hands, 1, 2, 3. Then the opportunity closes. The chair announces that we're all set.
And then.
no actions taken.
And no
No
actions, it's for the purpose, and the meeting is for the purpose of sharing things like the town is working on the bridge on South Stream Road, which may not be where it is, so,
Morgan Street.
Morgan Street. So you want to make sure that you don't send
Buses.
school buses down that road. They're going to have to find an alternative route, or, so it's for the purpose of sharing. We're going to be doing sidewalk work on X, or
so it's kind of a working.
it's a work, yes.
And it's sharing information that's already been shared in public meeting sessions.
Yeah.
Well, but it says more than that if you read it on the handout I got.
The handout you got, I wrote, so if there's any error on it, it was
Well,
my
but they
training
can
notes
talk
to
about
you.
budgets. I believe it said union contracts, new hires, facilities. I mean, the school
Nancy,
budget.
let me clarify. The contracts are, Stu would say, I'm opening negotiations with the police union, and we expect that to take 3 months. The SVSU might say, I am meeting with teachers union. We hope to, we're making progress. It may be saying there's no information that's not already publicly known, either at the SVSU level or the town level. It's just that, at least for me, I don't watch the SVSU meetings regularly, as well as the MAU meetings regularly, so this is an opportunity to share information that's helpful to all of us.
But the schools are made up 4 different towns, pay the budget. I really have an issue that, I know that our legislature members from our area used to meet with the school system. And I don't know why that stopped. They're the ones that should be meeting.
Nancy, could you get to your specific problem with the topic at hand?
Sure, I don't think that a minimum number of the select board should be meeting behind closed doors where the majority of us don't know what's going on and being discussed. I don't understand the need for it.
And there's not any secrecy there.
Right, I think that's the point that I'm having a hard time.
I mean, you could ask and we would tell you. It's just that because it's not a warned meeting, more than 3 of us can't attend, because then it would be a quorum. But in terms of it being secret information, absolutely not. Anyone can ask.
There's
It's-
nothing being discussed that you don't already know.
Or can't ask. I mean,
Well,
Then-
let's, what do you think?
sorry, yes.
No, it's an interesting construct, and what's interesting to me is that it's one that's not necessarily set up by this board.
No.
It's set up by
Previous boards.
this superintendent or.
Mm-hmm.
Well, it's generally the superintendent and the manager's office agree to meet on a given day
I get you.
to discuss, and the invitation goes
Yeah.
out.
Yeah, because it's informational nature, having a public meeting at which that informational stuff is being exchanged, in essence, is cumbersome. Is that?
It's cumbersome, and I dare say that we're relatively frank with each other in the sharing of information and what is working and what is not. So.
Yeah, I don't, Nancy, I can't answer the question, because I really want to, I guess, know more detail. I mean, I don't want to, the one thing I don't want to do tonight is start answering legal questions on specific.
Yeah, mine, it isn't
Issues.
specific, I just don't understand. I understand the quorum, but I don't understand why less than the quorum should be able to get together.
Well, I mean, I can answer that, which is that's what the statute deals with. A public meeting is defined as a quorum.
I understand that.
So, So you're not holding a public meeting under the open meetings law with less than a quorum.
But there's nothing covered that says the minority, less than a quorum, can get together with others and have discussions, where the majority doesn't know what's being discussed.
Yeah, there's nothing prohibiting that either, though. So, I mean, what the open meetings law is about is prohibiting public meetings.
Right.
And that, by definition, it doesn't sound to me like a public meeting, particularly if it's kind of a working meeting for the purposes of exchanging information. For instance, you as board members exchange, when you get packets of material and it goes out from the manager's office to all of you, technically you could say, well, isn't that a meeting? I mean,
It's just the exchange of
email to
information.
everybody, and it's about public information and material information. But by definition, when you're just exchanging information, and a decision's not in the process of being made, and of course, this town can't make a decision with 3 people showing up at a meeting. What is interesting to me, though, is I don't know. There's something in the. I'm just wondering if there's another way of.
Jim, if I could round out the
Dealing with it,
sort of the example that Jeannie gave before, a road being closed because of bridge work. It gets discussed in detail because the supervisory union might say to our town manager, we're going to send buses down this other road instead. And the town manager might say, oh, good, let me notify the Public Works Department that that's going to happen.
Right.
It's that kind of thing.
No, I get it. I
Yeah.
get that. So, and it's not sort of a legislative function. It's more
Absolutely not.
informational and exchange of information, et cetera. I get
And Nancy, I encourage you to step up and go if you'd like to.
And they're not secret. You use that term behind closed doors. They're not secret.
So then all of us, the entire board.
No, we can't because then we have a quorum, but you characterize it like there's something nefarious going
Well,
on.
to me, the easier way to do it be have someone from the select board go to a school board meeting, talk publicly, switch it back and forth. That way there's no question.
But it's covered this way, legally.
Well,
You just don't like it, and you can not
So,
like it.
If I
That's
may
fine.
I'm
interject,
just-
while we have you here, is this common practice in other towns? With
No,
just,
that's why it's like,
okay.
But that isn't to say that it doesn't work, but I can say what is very common in every town is that there's communication going on between departments or between municipalities and the school districts that are within the town. There's functioning, that's how you function. So there's obviously a lot of exchange of information that aren't happening in public meetings. It does not sound to me, I don't want to get trapped into answering a specific question here tonight because I don't know that I have enough real information, but it does not sound to me with less than a quorum as though a meeting is happening under the public meetings law. And really, no decisions are being made. It's more about the exchange of practical information
Right.
at kind of the management level.
I-
And then some of that information is getting, through to the board just for informational purposes. Did I say informal?
We understood what you said.
You've been here a while.
Maybe
But
I'm not, go ahead.
Maybe there's another way to do it to alleviate the concern, Nancy, or maybe, like you say, maybe one of the things is to go.
Right.
As one of the 3 to one of these and check it out. But I'm not hearing that there is some sort of violation of the open meetings law, but there may be another way to handle it to
Well-
alleviate the concern.
if our town has to deal with the school system involving a town facility and the board and the public doesn't know it, I think that is a big deal.
Yeah, but it doesn't sound like it's not that the board and the town doesn't know it. It sounds like an administrative decision is getting made to shut down a particular road because some repair work needs to be done or something like that. So buses are getting rerouted. or-
And we publish our roadworks every week.
Yeah, and that sort of information, so. Can I think about it a little bit?
Sure. I have a much stronger, I won't do it tonight, I have a much stronger one that happened in 2021 with 3 members of the select
Yeah,
board.
well, that sounds like water under the bridge, but
Thank you.
Well, it involved big money.
yes, sir.
I want to backpedal a bit and combine your comment about exchange of information, when you slide into forums and meetings and so forth. So, with email chain.
Yeah.
If a person has a bit of information, are they restricted from communicating with the entire select board to a very limited number of people on the select board, or set individuals since comment to the entire select board? Does that itself inherently become a open meeting law violation?
And it will depend on the context. So,
Ask you for a specific agenda. Is it possible to add X to next meeting agenda?
yeah. Usually those things, agenda sorts of item things, usually go to the manager and or the chair, right, to manage the agenda.
And they're open
But the
to,
concept of group chain emails, that's actually a good topic to discuss. Because you can violate the open meetings law by including a majority of the board on a chain email that addresses topics. So if you're giving opinions or you're wanting to discuss a particular topic and you're using a chain email to do that with 4 or more of your fellow board members, that can be a public meeting,
I
okay?
understand a discussion or exchange of information.
Yes, if
But a
it's,
specific request for, may we add this to our next meeting agenda? That's it. Nothing more?
Yeah.
Nothing else, no discussion of validity, appropriateness, or anything?
I think if you're sending an email, no, I think that's, I don't think I have a problem with that. As long as it's not addressing or discussing, but the problem with chain emails, and the reason I don't like them usually as an attorney, I discourage chain emails typically unless it is literally, here's the packet of materials for the upcoming meeting,
Statement of fact.
you know, that sort of thing. I typically discourage it because it slips so easily into
A
someone
discussion.
reacting. And as soon as someone reacts in some way and actually addresses one of the topics, now you're having a public meeting, and it's kind of out of control. It's really hard, particularly among 7 members of a board. So, you know, my preference as an attorney would be to discourage chain emails unless they're dealing specifically with, you know, here's the agenda, here's your board packet, or distributing information. For instance, you know, distributing information that I sent. You know, if you just distribute that and say, here it is, and there's no discussion, that's not a public meeting.
So can I ask a follow-up to that? So say someone sends an email to everybody on the board and says, Jeannie, I want to add having someone from state buildings and grounds come down and address us at the next meeting, right? So I'm going to have a thought about that. One, it's sort of like, why would we do that? Because it's a state level, it's not local, and it's not like that person is working with us. And so my choices in responding are to respond back only to the one person who's just sent this email to 7 people and say, interesting thought, tell me more about why this would be a good person to come, how it relates to our town's work, and let's think about that, and also whether there's some staff people that we should bring in to this conversation. So I'm having a back and forth with the person who sent the email, but that person sent it to everyone. So the likelihood of someone else on that email chain either addressing the person who sent the original email or asking me about what happened with that issue feels really high, and then that becomes a chain email.
Because there's all these emails now going off.
Yeah.
Jim, let me just point out that we open the meeting, every regular open meeting, to agenda setting for future meetings. So I have brought those things to the open meeting. I've heard from the public that they'd like to hear more about X. Can we add that to an agenda item?
Yeah.
Jeannie asks her questions about the why, what's the benefit, another board, that's when I think it's appropriate.
Yeah. I get it, and there are other ways of dealing with the agenda request, I get that.
Yep.
But, I'm just going from a particular technical situation, as asked by Mr. Adams here. I don't think his request to you,
I agree.
I'd like to have this as an agenda item.
Yeah.
Maybe the response could be, fine, why don't you bring it up at the next meeting? Something along those lines.
Okay, that would do it.
But that does become that email becomes a public record.
Yeah,
Yes.
absolutely. Yeah, those are all public documents and public records.
Yeah. Okay, so that's a fine response, because the worry always is that as
You gotta
soon,
engage.
because everyone knows about it, then everyone is like, oh, wonder what we're gonna do with that. And I don't wanna have that
Or it'll
conversation.
start an engagement like, well, why the heck is that guy coming, or what are we gonna do with that guy?
Yeah.
And then
Yeah.
it starts to get a little bit out of
Yeah.
control.
Yeah.
But I don't think that there's any harm in notifying you, as the chair, and you, Stuart, as the town manager, that I'd like to see this addressed, and I'd like to see this person come to it.
Oh, coming to the two of us, I think no problem at all.
And then.
Yeah. Yeah, it's more when it goes to everyone, because then the potential for conversation.
Yeah. But even it
Increases.
going to everyone, that email in and of itself is a public document.
Right.
But I don't think that's a public meeting either.
Right. I agree.
So then it's a matter of just how best to deal with getting that on the agenda, or having a discussion with
Yeah.
the board about getting it.
Yeah, and having individual board members understand that they should not then have any further conversation about it. Yep.
Can I ask one more
But-
question?
But now everybody knows that, right?
Yeah.
We can't have a conversation.
Yeah.
about it.
I don't know if this is an open meeting law topic or not, but when the warning for a meeting goes out with the agenda, are we bound by that agenda that that's what we can discuss? We should not, or maybe I'm wrong, should we discuss things at an open meeting that were not warned on the agenda?
Well, there's a little bit of a distinction between whether it's a regular meeting and whether it's a special meeting.
No, just a regular public
So
meeting.
a regular meeting, your procedures and policies, particularly if you adopt the ones that you're going to be, I think, considering, would really favor and want you to stick to the agenda items, but there's usually also a place on the agenda
Right,
itself
right.
to make adjustments
Yeah.
to the agenda.
Yeah, and then we will always have other
To
business.
vote, and that's fair. I think it's
So
fair
we
to
have,
consider.
on
But that's a
our-
voted item, right?
we vote
Or do you
to,
not vote it? Or is
No, we
that
do.
the chair?
No, we do vote.
We vote, and if we want to amend the agenda, we do it as the first item, and we do that.
And you do it as a
And we
vote.
do it as a vote.
And we have an agenda item, other business.
Where we don't discuss things, but you can bring up ideas.
Yeah, just topics. Yeah.
I think that's the best way.
Okay.
Okay,
all right.
thank you.
we're in agreement, that's good.
Okay, that's good. Any other questions?
Thank you so much, everybody. It's great to
thank
be
you.
involved.
Great stuff.
Thank you. And we kept you an hour over, so thank you very, very much. We have reason for an executive session for the purposes of personnel. So we will, yes. So could I have a motion to go into executive session? We'll take a 3-minute
I'm
break
going to walk
after.
out with you, Jim,
We'll
because
take
I'm
a
not part of
3-minute
this.
Still move.
Okay,
And a second.
all right. All those in favor, please say aye.
Aye.
Aye.